interest.
Tape number one was a videotape deposition of Mr. Emmanuel Goldstein in the matter Universal City Studios, Inc. et al. Plaintiff versus Sean C. Remedies et al. Defendants. In the United States District Court, Southern District of New York, number 00CIB277LIKRLE. This deposition is being held at 1585 Broadway on June the 27th, 2000 at approximately 10:20 a.m. My name is Ruben Martinez from the firm of S5 Video Services. The court reporter is Mr. Thompson Nichols in association with S5 Deposition Services. Would the counselors please introduce themselves?
My name is Leon Gold. I'm with Proskauer Rose, counsel to the plaintiffs.
Harlow Miller with Proskauer Rose, counsel to all plaintiffs.
Mark Lichtback with the Motion Picture Association of America, counsel for plaintiffs.
Jessica Plankett, Silver Associates.
Martin Garbus, Frankfurt Garbus, one of the attorneys for the defendant.
Edward Ernstad, Frankfurt Garbus.
Would the court reporter please swear in the witness?
Just let me note that the caption you read is incorrect and should be changed, that two of the people you mentioned are no longer part of the case, but we will give you a correct caption before you type this up.
Mr. Goldstein, do you swear to testify about the truth, the whole truth, not about the truth, so help you God?
I did.
Actually, Martin, I don't think the caption has ever been officially changed.
It has.
Did you file something?
Yes.
We didn't file anything, and Ms. Reyes, the judge's law clerk, asks, every time we go to court, she asks, what's going on? Aren't these people out of the case? And she said she was going to talk to the clerk about getting it changed.
Thus, it isn't changed.
I think it's been done, but I don't know for sure.
Because our understanding procedurally was that the defendants that had settled out had to make a motion to change the caption to remove their names. So we'll figure that out.
That's fine.
We'll figure that out, yeah. I hope that the judge's deputy can take care of it.
Perhaps.
Right.
Mr. Goldstein, do you understand that people who create artistic work are entitled to copyright protection?
Absolutely. I object to the question. Direct the witness not to answer.
Almost grand.
I think he's being examined as a fact witness.
I asked him what understanding he has.
I object to the question. I'll allow the witness to answer.
What rights do you understand copyright holders have?
Object to the question.
Answer anyway? Okay. Basically, if you create something, you're entitled to benefit from it. No problem with that.
Do you understand that copyright holders who have a right to decide who can see or use their work?
That's not my understanding of how copyright works.
What is your understanding of how copyright works?
I think I'll object to this, and I'll direct the witness not to answer. The witness is not a lawyer. The same objections were made when Mr. Valenti was being examined, and he was directed not to answer the question. I'll direct the witness not to answer.
Do you understand that people who have copyrights have the right to maximize their return from the copyright?
Yes.
And what does that mean to you, maximize the right? Maximize the return on their copyrighted work?
It means they're entitled to benefit, however much the market dictates they'll benefit from the selling of their work.
And you understand that the motion picture companies who have copyrights on their movies have that right?
Yes.
Do copyright holders have the right to decide, as you understand it, who will see their work?
I object to the question.
I don't see how that's possible.
Well, do they have the copyright holders have the right? For instance, if the copyright holder is a novelist, do you understand he'd have the right to decide who can sell his books to the public?
I object to it. With Mr. Goldstein's version of the copyright law is not at issue. What is at issue is what he did. And to suggest that because he has one set of beliefs rather than another set of beliefs, something that is lawful and appropriate is somehow unlawful and appropriate because any view he has, it seems to me, is improper. It seems to me what you're doing is you're asking questions for the benefit of the viewing audience, and the judge would not permit at a trial the kinds of questions you're now asking.
You can answer the question.
I forgot the question.
Yes, certainly. Can you read the question back?
The copyright holders have the right, for instance, if the copyright holder is a novelist, do you understand that he would have the right to decide who can sell his books to the public?
Yes.
Do you understand that copyright holders have the right to protect their work against people who would use it without permission?
Absolutely.
Do you believe that anyone is entitled to assist others in using or taking the copyright work without permission?
I object to the form of the question. I would wait for direction from the judge before the witness is required to answer that.
You're directing the witness not to answer that question?
No, I'll allow the witness to answer.
Thank you.
I'd like to speak to the witness for 5 minutes at this point before we go on with the deposition.
Well, first of all, you want to answer the pending question. Would you read the question back to the witness?
Do you think that anyone is entitled to assist others in using or taking the copyright work without permission?
I think that depends on the definition of the word assist. If you're explaining how technology works, then absolutely you're allowed to describe that, to explain that. If you're talking about leading somebody by the hand to make an illegal copy of something, then no, absolutely not.
Can we take that 5-minute break?
Well, I object to that, Mr. Vargas, because I think, based on what we've done so far, and since we've only started about 7 minutes ago, that there can't be any reason for a break other than to instruct your witness on how to deal with certain questions along the lines I'm asking. So I'm going to take that position with the judge. I think it's improper.
Okay. We had, as a courtesy throughout these depositions, irrespective of when it occurred, always allowed, and this happened repeatedly with your witnesses, any time a lawyer defending a case said, I'd like to speak to a witness, even when a question was posed. We had extended that courtesy to each other. Basically, we extended it to you because these were your witnesses being examined. I would just expect that we would get the same courtesy here.
Yes, but we didn't take a break 5 minutes after the deposition.
No, yes, we did. We did the exact same thing previously. I don't have all the depositions in front of me. My memory is we did it with Schumann.
What's your understanding of the meaning of the word assist?
I would object to the form. This witness is not a lawyer. He's not being deposed as a lawyer. He's a journalist who printed information. And I think to ask him his definition of assist is improper, except to the extent that he had conversations with his lawyer. And with his lawyer, he had discussions of that word. And to that extent, I would claim a privilege with respect to it. Do you have any independent knowledge of what that word means other than the conversations you've had with me or with Mr. Hernstat? And if it's based on conversations you've had with me and Mr. Hernstat, then just say it's based on conversations with your lawyer, and then it's privileged.
Well, we did discuss that, so we have to say it's privileged.
Do you ever use the word assist in your writing?
I may have on occasion.
What does it mean when you use it?
To help, but it's a very general type of a word.
Just tell me what it means to you when you write.
Aid.
To help or aid? Okay. Using that definition of the word assist, do you understand that anyone is entitled to assist others in taking or using a copyright work without permission?
I'll object to it. To the extent that your knowledge of the copyright law or the words assist come from conversations with me or your attorneys, and just say it. And to the extent that these discussions were held in the context of preparation for this case, it has been privileged.
Well, again, that's something that we discussed. Whether it's a synonym or the word assist, it's still something we've discussed.
Prior to that, when did that discussion take place? Just the date?
Before we came over here?
Today?
Yes.
Okay. And you spent about an hour?
Not on the word assist, but yeah, on various things. Yeah.
Okay. Had you met with him before for the purpose of preparing for your deposition?
Once, yes.
When was that?
Yesterday.
When was it you talked about whether anyone is entitled to assist others in taking someone's copyrighted work without permission?
I'll object to the question.
Today or yesterday?
I'll object to the question. It's privileged. When he spoke to his lawyer about it is irrelevant. It's privileged.
Can I answer?
Yes.
Today.
Did you have any understanding prior to yesterday of whether anyone was entitled to assist others in using a copyrighted work without permission?
I'll object to it, except to the extent that you had some awareness of whether linking was permitted or not permitted and where you got that understanding.
I'm not interested in your definition of the word linking or posting in this question. What I'm asking you is, before you talk to your lawyer about the subject, your present lawyers about the subject, did you have any understanding before that of whether anyone was entitled to assist others in taking a copyrighted work without permission?
I object to it. That's specifically objective form. That specifically relates to the question of linking. So if he had some knowledge of whether linking was permissible or not permissible, the question is, did he have any discussions about linking, or did he have any knowledge, either from the previous court's decision or now, about linking, which is what assisting is?
Could you read the question back to the witness, and then I'm going to ask you to answer that?
Did you have any understanding prior to yesterday of whether anyone was entitled to assist others in using a copyrighted work without permission?
I had an opinion, yes.
What was your opinion?
That any kind of copyright infringement is wrong. And helping someone, obviously, to infringe upon copyright would be wrong, too.
To yesterday, did you have any understanding of whether anyone was entitled to break through a protective device which protects digital copyrighted work in order to take that work without permission?
Objection, unless you're also including out the term fair use. It's misleading unless you put that qualifier in the sentence.
Do you remember your question? The question, Mr. Johnson?
I appreciate having it read back.
Prior to yesterday, did you have any understanding of whether anyone was entitled to break through a protective device which protects digital copyrighted work in order to take that work without permission?
Yes.
And what was your understanding?
That kind of thing is wrong. That taking something without permission is wrong.
And prior to yesterday, did you have the same understanding? Striker. Is there a time in 1999 when you were posting DeCSS?
In 1999, as of I believe late November, we mirrored the site on our website. On our website.
Did 2600 ever post DeCSS?
That's what mirroring is.
Yes. For what purpose?
At the time, it had only just happened a couple of weeks earlier. We had noted the events that someone had figured out the encryption standard being used by DVDs, and had found it to be rather badly written. When we saw that those people were being intimidated and forced to shut down their websites, as journalists, we stood up and said, this is wrong. And then we were listed in all future court records.
You only mirrored DeCSS after the suit was started?
No, we mirrored DeCSS after we became aware that people around the world were being threatened because they were showing people how the encryption worked.
And what was the purpose?
Well, as journalists, we have a very firm sense of freedom of information, and we believe people have the right to know how things work. As a publisher of a magazine that deals with such issues, I feel strongly that we all have both the desire and the right to know how things around us operate, and I don't see that as related in any way to theft of those services.
When you mirrored or posted DeCSS on 2600, how did you make sure that people who simply wanted to see movies that were copyrighted without buying them would not use DeCSS?
Well, there's two answers to that. First of all, when you tell someone how something works, when you give information out, people can always use information in a good or a bad way. That's just the nature of information. The second part of that is that what was posted, DeCSS, has got nothing to do with illegal copies. And I think that's been proven time again. I don't think a single case of copyright violation has been traced to DeCSS. Copies of DVDs have been made. We had, in fact, reported 2 years earlier, on November 25th, 1997, on one of our radio shows, that illegal copies of DVDs were being made in what is known as bit-by-bit transfer, using a program called Soft DVD. And what the DeCSS code showed instead was that the encryption was weak, and that encryption was more about control of the playing back as to where you played it back and how you played it back, not making copies.
Did you understand at the time you posted DeCSS that most people who own computers would not understand how DeCSS works, even if they downloaded DeCSS?
Most people I know who have computers would understand it.
But you know far fewer than 50% of the people in the United States that have computers.
Absolutely.
You know far fewer than 2% of the people who own computers.
We reach 1/10 of 1 billion.
I don't know that many people. But
did you believe it was appropriate to post DeCSS even though 10 people, and only 10 people, might use it, might download it for the purpose of finding out how it works?
I'll object to the form of the question. No proof that 10 people have used it. And I object to the form of the question whether he knew or understood it.
I'd have to say that if I applied that logic to everything I wrote, I wouldn't be writing anything. Because someone can always take what I've written and use it in a bad way, and then I'd be up nights worrying about, what they did wrong. I don't think anyone has ever used DeCSS to pirate a film.
Do I take it that you agree that you have the right, or you believe you have the right to post DeCSS, even though far less than 1% of the people who would download it would have any interest in how CSS or DeCSS works?
I object to the formalization.
I'm not sure it's possible to say how many people who downloaded it understand it. I don't think a significant portion of the American public downloaded it. I do think the people who went to the website read the text that surrounded it and hopefully learned something from the text, and if they were interested in pursuing it further, learning more about the technology, then they had to look at the program as well.
Well, you could have... Was there anything wrong in your printing the text that accompanied the letters DeCSS?
I'm not sure I understand.
You had an absolute right, didn't you, in saying whatever you said on your website, except for DeCSS, isn't that right?
Object to the formal question. Can you refer to the term DeCSS on his website? Is that the question?
You can answer.
Can you just repeat that back? It's a little unclear.
I don't understand the question. I don't know if the witness understands.
You have the right in there saying whatever you had on your website except for DeCSS. Isn't that right?
I had the right to say what I said on the website, and I believe that extends to posting the code as well.
Do you or any corporation you're affiliated with have a copyright, own a copyright?
Yeah, our words are copywritten in our magazines.
And why did you? Who caused them to be copyrighted?
I did.
Why?
It's standard to have a copyright to protect your interest. Someone could take 2600 and just simply reproduce it if we had no copyright.
What interests were you protecting?
Well, our interests, obviously. We have words that we write, and we don't want somebody else just taking them. But by the same token, we have no problem with people spreading our information around, because we write it for the purpose of being read. But we do hold the copyright.
I think I'm confused. I don't understand why you have the copyright if you say that you don't care who uses your material.
Well, there's different standards of use. If someone were to take our magazine and simply duplicate it, well, that's obviously very bad. If somebody were to, say, quote something from one of our articles, we have no problem with that. We consider that fair use.
In other words, if they quoted something but not the whole thing, you consider that okay.
Right.
But you were and when you got the copyright, one of the purposes was to protect anyone from taking the whole thing.
Yeah.
Is it your understanding that the current court injunction against your posting DeCSS violates your right?
I wouldn't say it violates my rights. I say that it's open to contention whether it's right or not. But obviously, we're following the injunction.
Do you?
We respect it.
Excuse me. I'm sorry. Did you get the complete answer?
Yes, I did.
Do you believe that the current court injunction violates rights that you have in any way, shape, or form?
Objective form.
Or do you believe the current court injunction is perfectly proper and appropriate? And I'm asking for your beliefs.
Object to the question, and if you can exclude anything, you can from any privileged communication. And any conversation with counsel telling you what your rights are. So to the extent that it comes out of conversation with counsel, just say that, not claim privilege.
I respect the injunction.
Excuse me, sir.
I respect the injunction. I don't believe the injunction is violating my rights per se. I think it's a fight that we're engaged in, and obviously the injunction was filed against us. We respect that, and we followed it. So,
well, do you understand that the injunction prohibits you and 2600 from posting DeCSS?
And we've done just that.
And do you think it's appropriate and right that the court did that?
I object to it. To the extent that what the judge did is right or wrong, that conversations you had with counsel.
Oh my gosh. Oh my gosh. Morton, I object to what you're doing.
I see a difference between what the judge said and what the people behind the case are saying. Obviously, I don't believe the people behind the case are right. I don't think the judge acted improperly. I think the judge is doing what judges do. And I have every faith in
What do judges do?
Judges make decisions based on the evidence given to them. And it's my hope that we'll present evidence to prove that we're right in the end.
Your Honor, do you know this motion to vacate the injunction?
Well, then I take it you don't believe that the injunction is inappropriate.
The injunction in itself.
I object to the form of the question.
Do you think you have a right to post DeCSS?
Yes, I do.
Why?
I consider it a form of speech. I consider it a form of basically writing about technology, showing how things work, and I think it's a very it's a chilling effect if you start punishing people for showing how something works. It's one step away from punishing someone for talking about it, and I think as journalists we need to stand up to that.
I'd like to have this marked as Plaintiff's Exhibit 1. Thank you. I'm going to show you Exhibit 1, Mr. Goldstein. Give you a chance to look at it. It won't take very long.
Okay.
What does that mean to you?
It means you've written DeCSS on a piece of paper.
But what does it mean?
What does it mean?
Yes.
It doesn't really mean a whole lot to me, to be honest.
I see, sir.
You've written something on a piece of paper, but this is not the same thing as the DeCSS code.
Does you say that it's not the DeCSS code? Is that right?
5 letters on a piece of paper? No, sir, it's not.
Is that a word?
I object to the form of the question.
DeCSS.
I object to the form of the question. I direct the witness not to answer. DeCSS speaks for itself. You wrote 5 letters on a piece.
You're going to direct the witness not to answer? On what ground?
Can you tell me where you're going with this deposition?
No.
We've now been here. It's now close to 11 o'clock. It seems to me what you've done in your last hand is ask questions about really relevance to the
I'm sorry. I'm sorry.
I appreciate it. Don't apologize for talking. I appreciate it to get to the questions that I perceive to be are at issue in this lawsuit. I mean, I think it's very cute to write DeCSS on a piece of paper, and I presume you've been examining for half an hour on it. But it has nothing to do with the issues in this lawsuit. My understanding is that 5 words, not 5 letters, were on the piece of paper.
I think an objection is okay, but you're filibustering. No, I think you're filibustering. That's not an objection. That's improper. Now you can answer the question. What does that? Is that a word? DeCSS?
Not in the English language. It's 5 letters. It stands for something.
And I take it has no meaning to you.
In that form? Well, it has meaning in that it represents something. It represents what we're talking about today. Other than that, I'm not sure if that's the way you're presenting it.
Thank you. Do you believe that when you were posting DeCSS, you were engaged in an act of civil disobedience?
Objection. I've already testified in the media, which presenting as part of the story.
When we first posted it, we posted it as journalists talking about a news story.
How was the posting accomplished?
The posting of the actual DeCSS or the articles?
The posting of DeCSS, of what you call the actual DeCSS.
I wasn't the person who actually copied it, but I imagine it was taken from one of the sites that had it up on the net. We verified what was in it and put it up on our site.
By whom?
Probably our webmaster.
And who's that, sir?
Webmaster.
And who's that, sir?
His online name is Mackey.
That's his real name?
I know his first name. His first name is Micah. His last name begins with the letter S. And that's really all I know. I know how to email him. I know how to get a hold of him, but I don't know his full last name.
He's not employed by you?
No.
Did you ask him to post DeCSS on your site?
We talked about it and agreed that was the appropriate thing to do.
So you did ask him to do it?
We conferred. We agreed together. I didn't direct him to do this.
Does he have any ownership of your site?
Not as such. I mean, he has a say in the kinds of things that go on there.
Do you have an ownership of your site?
Yes. Yeah.
You own stock in the company that controls your site?
It's a private corporation, yes.
Approve of what he did, posting the CSS on your site? DeCSS on your site?
Yes.
In the past 6 months, have you been engaged in any kind of reverse engineering of anything?
I'm a journalist. I'm not an engineer.
So the answer is no, sir?
The answer is no.
In the last 6 months, have you been engaged in any cryptographical research?
No.
Prior to the court proceedings, did you talk to any people about DeCSS who were, in fact, engaged or planning to engage in reverse engineering?
Not with my knowledge. I talked to a lot of people on the internet. People message back and forth, and some might be very knowledgeable in certain fields. So it's very hard for me to say that whether or not I was talking to somebody who was doing something like that.
Since the commencement of this lawsuit, have you talked to any people who are using DeCSS for the purpose of reverse engineering?
To be honest, I've never found anybody who's successfully gotten DeCSS to work.
The answer to my question is no.
No.
You haven't talked to any people. And where did you get the understanding that people can't get DeCSS to work?
I've gotten messages, again, on the internet. I remember back towards the later part of last year seeing messages from people who were trying to figure it out, and it was too complex for them. I imagine there are some people who have gotten it to work and have been able to view DVDs on their Linux machines, which is the purpose of it. But myself, I have not talked to anybody personally who's done that.
To your knowledge, is anyone in the world currently engaged in reverse engineering DeCSS or CSS?
Which?
CSS.
Well, I think it's already been done. I think CSS has pretty much been shown to be not very secure encryption-wise.
Do you know any of any cryptographical research with respect to DeCSS that's been done anywhere in the world?
Not specifically, no.
How did you come to the understanding that the purpose of DeCSS was to view movies on a Linux machine?
There's been quite a lot of discussion in various forums and at conferences and various places like that by people who are extremely knowledgeable in the field, from the founders of Linux to its users. And it became very clear very quickly that this program was simply made so that they would have a way of viewing DVDs as well, since they were not granted a license to have a DVD player on their machines.
Do you know if there is a Linux-based DVD player that exists now?
I had heard there was something being developed. that was not open source. It was closed source, but it was something that was being developed.
Well, then how are people... Strike that. Why do you say the purpose of DeCSS was to allow DVDs to be played in a Linux-based player if there is no Linux-based player?
Because by using DeCSS, you would have a Linux-based player, which previously did not exist. In fact, previously was illegal.
You mean that in order to play the movies that you're talking about, people are decrypting CSS?
The only way to play a movie on a Linux machine is to decrypt it so that you can see it on a different platform. The way it had been before, you had to buy a particular operating system or a particular machine that had already been granted a license, which meant that the thousands, millions of people with Linux machines were unable to use DVDs. They'd already bought the DVDs, they'd already bought the computers, but they were unable to use them.
Is that because the people that held the copyrights to the movies encrypted DVDs so they couldn't be played except on a licensed player?
My understanding is that they encrypted them and only gave licenses to organizations willing to pay very large fees, and that's basically my understanding of it.
Once you decrypt the movie, how can you play it if there's no player?
You're talking about a Linux system, a Linux operating system? Objection to the forward question.
Yes, we are talking about
You don't understand technology, Mr. Cole. I object to the forward question. Doesn't make sense. Go ahead. Answer.
Ask one more time so I'm clear.
Once you decrypt the movie, how can you watch it if there's no player?
My understanding with the way DeCSS works, and I could be wrong because I've never used it myself, is that by using this particular tool, you then have a player that will allow you to play the film that you've decrypted. And if that's not the case, then there might be another utility out there that does make a player. It's a software-based player.
You're not sure?
I'm not entirely sure on that, no.
When did you first find out, as you say, that the purpose of DeCSS was to view movies on a Linux player?
Well, right away, that we knew that was the primary purpose. And
how did you know?
By talking to people who are experts in the field of Linux.
Who did you talk to?
I know there are some people involved in the Livid project.
What project?
Livid, L-I-V-I-D, which was a project to make a DVD player for Linux, which has been going on for quite some time.
My question was, who did you talk to? What person did you talk to?
I don't know specific names, unfortunately. I mean, these are people I talked to either online or met briefly at a conference.
What is the icing? You have no record of the fact that they gave you this information, no written record?
I have no written record myself, but it's been posted in many public forums.
Did you exchange communications with the people involved in the Livid project by email?
I may have at some point last year when it was first unfolding, yes.
Do you have those emails?
No.
You wipe them out of
I don't save outgoing mail, and I'm very stingy with what I save because I get so much mail.
Can it be retrieved from your hard drive?
No, it's so long ago.
For how long can you retrieve messages on your hard drive?
I've never tried. I mean, it's a Unix-based system. I think it's not like the White House. It's very difficult to retrieve something.
Was it fair to say you actually don't know whether or not these messages could be retrieved?
Oh, I'm pretty positive they can't be retrieved.
When you mean pretty positive, what does pretty positive mean? Not positive or positive?
I'm positive.
Positive?
Yeah.
did you get to know that it is positive that you can't retrieve messages that are 6 months old?
Well, I based that on when I wanted to retrieve things in the past, and I asked sysadmins, can I get sysadmins? I asked them, can I get this back? And they say no way. I imagine that probably holds true no matter what the contents were.
And you have no knowledge of anyone in the Livid project that you talked to about DeCSS?
Not off the top of my head. I mean, it's not that large an organization, so I don't think it's difficult to figure out.
Legal space in the deposition, Mr. Goldstein returns the deposition, so you can call him in or put him in the deposition.
Okay. Do you know any people who belong or who work on the Livid project, whether or not you've talked to them?
Just through communication and possibly meeting them at a conference.
And do you know their names?
I probably remember if I heard them, but I don't remember the names off the top of my head.
What is the Livid project?
As I said, Livid project, my understanding, is an ongoing project to make a DVD player for Linux machines.
And they're still at it?
I believe so.
How do you know?
I've just heard from various public discussions.
Prior to your conversations with your attorneys this week, did you believe that you were allowed to post DeCSS or link to other sites posting DeCSS as long as several people downloaded DeCSS to engage in cryptographical research?
Can I hear the question again?
Prior to the conversations with your attorneys this week, did you believe that you were allowed to post DeCSS or link to other sites posting DeCSS as long as several people downloaded DeCSS to engage in cryptographical research?
I object to the form of the question. It's several questions in one. Can't you just ask the question simply? There are just several different parts of the question, Mr. Cole. Don't you see that? Do you understand the question? Can you answer?
I'll give it my best shot. Basically, I think it's not a conditional thing. When you post something as long as somebody downloads it for a particular purpose. Our understanding was that it was perfectly okay to post this. Obviously, when the injunction happened, we stopped posting it, and linking is a completely different issue.
So I take it was not your understanding that you were allowed to post DeCSS as long as several people downloaded DeCSS
I object to the form
in order to engage in cryptographical research.
Well, I mean, I think I answered as best I can. It's not a yes/no question. They have a conditional phrase in there, so.
Is it your belief that you can that DeCSS can be made available to anyone in the United States as long as a few people use it for cryptographical research or reverse engineering?
I object to the form of the question. I don't understand that it's a conditional question. Can't you rephrase the question in an intelligible way?
You can answer, Mr.
Again, it's information. We can't put conditions on the exchange of information and say you can only read this if you're going to use it in a particular way. We put up information on our site and people read it. And that's the relationship we have.
So your right to post DeCSS doesn't derive from the fact that it doesn't derive from how it is used by the end user. Is that right?
I'll object to it. That's not what the witness said.
Is it true? I don't care what the witness said. I'm asking.
Yeah, but then you can't rephrase if you don't care what the witness said, Mr. Gold, then you can't say, isn't this what you just said? If you're not going to listen to the witness, then don't listen to the witness. But you can't phrase questions that way. I object to the form of the question. And you know better than that.
Do you believe that DeCSS can be made available to anyone in the United States, no strike rate. Do you believe that the end use of DeCSS has nothing to do with the lawfulness of posting it?
I object to the form of the question. I object to the question on the grounds that it calls for legal conclusion. This witness is not a lawyer, nor should he be asked about questions concerning legal conclusions. If there's anything in that question that comes as a result of conversations that you and I have had as counsel, namely with respect to legal conclusions, just say it. If you think you can answer the question in some intelligible way, then answer it.
Could you read back the question, please?
Mr. Gold, I don't know what you're doing. These questions are not admissible at a trial. The judge won't let you ask them, so why ask them here now?
I think the witness has to reread the question.
Yeah. Do you believe that the end use of DeCSS has nothing to do with the lawfulness of posting it?
Can't answer the question, so you can't answer the question.
It's a really hard question for you to answer. I don't think they're related, no. That's my view as a journalist. I'm not a legal expert.
Mr. Roberts, I'm going to respectfully request that you cease from directing your witness on how to answer a question. If you wanted to do that before you came here today, you had ample opportunity.
I had no...
If it continues, I'll take it to the judge, and we'll play the movie.
Whatever you want to do.
I'll have to. It's inappropriate. Prior to talking to your lawyer in the last 2 days, did you have an understanding of the meaning of the word fair use?
Yes.
Is that an understanding you came to through your profession as a journalist?
Yes.
And what was that understanding?
That it's legal to use bits of copyrighted material for the purpose of describing something, showing an example of something. For instance, even a student presenting something to a class might play something from a videotape, for instance. That's fair use. You might see something on television that shows a scene from a particular movie. That's fair use. A parody is fair use.
Was it your understanding before you talked to your lawyers in the past 2 days that fair use only related to using bits of copyrighted work or pieces of copyrighted work, but not the whole thing?
That's my understanding. The whole thing isn't exactly fair use.
I'd like to have this marked as Plaintiff's Exhibit number 2, a document which on its cover says 2600, The Hacker Quarterly, Volume 17, Number 1, Spring 2000. Can you describe that document, Mr. Goldstein?
Yes, this is the magazine I published, 2600, The Hacker Quarterly. This is The Hacker Quarterly. This is the Spring 2000 edition.
On page 7, there's what appears to be a photograph.
Yes.
Is that in fact a photograph?
It's a doctored photograph. This is it's parody. It's basically taken from the World Trade Organization demonstrations, and we slapped MPAA on the back of their jackets.
So is it true that the only thing in this picture that's not true, not actual, are the initials MPAA?
Well, the initials are...
Well, I mean, That's not a photograph of somebody.
No, as I said, we put MPAA over whatever was there before, if there was anything there before. So no, there were not MPAA stormtroopers in the streets.
But pictures of these troops or police people, that was an actual photo?
That was an actual photograph, yes. I was taken in Seattle in November.
And in what demonstration did you say?
World Trade Organization.
And what was the demonstration about?
That was a demonstration against the World Trade Organization in Seattle, November 30th, I think.
In the second paragraph, there's some discussion about a Mitnick. I gather that's a Mr. Mitnick, page 5.
Page 5? Yes.
Who is he?
Kevin Mitnick was a computer hacker who had been in prison for 5 years.
Do you know what he was convicted of?
In the end, he was convicted of basically misrepresenting himself on the telephone and having source code that belonged to cellular phone companies that he was looking at.
Do you know anything about the charge of misrepresenting himself on the telephone?
It's basically calling someone on the phone saying that you're an employee of a particular company when you're not, in order to get some bit of information. That's my understanding of it in his particular case.
And that's the only crime you know of that he was convicted?
In the end, that's the only crime he was charged with, yes. And that's why we took the case up, because we thought it was rather unfair that someone be locked away for 5 years for something rather minor.
And when you say you took the case up, what does that mean?
As far as writing about it, as far as following it, and we're currently producing a documentary on it.
Where did 2600 come from?
You mean the
part of the name of the hacker portal?
Well, 2600 is a frequency that, if you go back into history, back into the early 1960s, when people first started exploring the phone network, the sound of 2600 hertz tones would basically disconnect whatever call you were connected to and put you in what's known as operator mode, where you could basically explore the entire phone network. That was back in the day when there was just one phone network run by AT&T.
Could you then make calls without paying?
That was one thing you could do, but you could also explore and talk to operators in various places and just learn how the whole thing was pieced together. And that's where the term phone phreaking was established. That's where a lot of hackers trace their roots to, just exploring one of the first major computer systems in existence.
And you adopted the 2600 as your masthead, your banner?
Yeah, well, the number had some significance, and it was rather an unusual name, so it appealed to us.
Were you ever involved in any activity in any way relating to abusing the phone system?
No.
Did you ever make phone calls without paying for them?
No.
No, my objection to the question. And the previous question.
Have you ever been convicted of any crime?
Objection.
I'd gotten in trouble for computer hacking in 1984, which was the first year our magazine came out.
I object to the question. I object to the line of inquiry. I think I'll do that because it's not very nice.
Come on, friend.
And I would ask you to go on. If you get a little court that is favored, answer the question.
When you use the word in trouble, sir, what did that mean to you?
I object to the question.
And directly is not the answer until such time as the court rules.
back for a second, sir?
Sure.
Thank you. Turning to page 6 of the document, the right-hand column, about in the middle of the paragraph, which is the last full paragraph on the page. The following words are written. Quote, so, under the DMCA, it is illegal to play your DVD on your computer if your computer isn't licensed for it, close quote.
I don't see where you are.
You don't see the language?
I see.
Have you got it now?
I have it now.
Okay. Is that true?
That's...
I object to it. It's a legal conclusion.
And that's my understanding. I mean, I wrote that piece.
What's that, sir?
I wrote that piece.
Yeah.
So that is my understanding. Yes.
And how did you come to that understanding?
I'll object to it. I think I'll direct the witness not to answer. It's a legal conclusion.
Again.
If the judge directs him to answer, then he'll answer the question.
The next sentence states, quote, it's illegal for you to figure out a way to play a European DVD on your TV set. Is that true?
I'll object to the question, direct the witness not to answer, calls for conclusion of law. If the judge directs a journalist to answer about something that is written, then I'll of course answer.
And if the last sentence says, if you rent a DVD, I think it says, and if you rent a DVD from your local video store, figuring out a way to bypass the commercials in the beginning could land you in court or even prison, close quote. Is that true?
I direct the witness not to answer. It calls for a legal conclusion. To the extent that it's based on conversations with counsel, it comes with a privilege. The judge decides that the privilege doesn't apply, or that he should answer the question, then he certainly will.
I believe, Mr. Goldstein, that you wrote this piece that we're now making some kind of fair use of.
Yeah, you make copies of it. That's perfectly okay.
Thank you, sir.
Sure. Now, if that was a DVD, you might have some trouble.
What's that, sir?
If that was a DVD, it might be a different story.
You mean if anyone makes a copy of a DVD, he violates the law? Is that what you mean?
I'll object to the question.
Do you believe that, sir?
I'll object to the question. 2600 wouldn't sue. DVD might sue. MPAA might sue. It's not just a question of the law. I direct the witness not to answer.
The end of that page, the following is contained. The world, the MPAA, and mega corporations want us to live in is a living hell. Close quote. What did you mean by living hell?
Well, what we're going through right now is kind of a living hell. I see that happening to a lot more people.
So the only thing you meant by living hell is that the MPAA would cause suits to be brought against people who thought were violating the law?
I believe Jack Valente said they'd file 1,000 lawsuits a day if necessary.
Against people who violate the law?
Against people they feel like filing suits against.
Is that what he said, or did you just make that up?
Not the last part, but he did say 1,000 lawsuits a day. That was accurate.
Was he talking about lawbreakers?
I'll object to it.
Did you understand that he was talking about lawbreakers?
I don't really know what he was talking about, to be honest. He basically seemed to think that lots of people are lawbreakers without really describing how they broke the law.
Can we take our morning break now? It's 11:30.
Sure.
The time is 11:22 a.m. Going off the record. time is 11:40 a.m. We're back on the record.
Mr. Goldstein, did
I'm going to withdraw my objection to your question about the 1984. If you wanted to sue it, you can pursue it.
Oh.
And it's appropriate if you want to pursue it, you should sue it.
You referred, I believe, to getting in some trouble in 1984.
Yeah.
What's that about?
It involved one of the first cases of computer hacking. Basically, there was a system, still is a system known as Telenet, where basically it was protected with one-letter passwords, the letter A, and a lot of organizations were wide open. Raytheon, Coca-Cola, in fact, in the executive office of the president. And when they finally discovered that their system was wide open, I basically came forward and explained it to them. I was indicted, but I think I was dealt with fairly. I paid restitution and was on probation. I never did it again. And from that point, I've tried to set a good example for the magazine so people don't make that kind of mistake, and so that they're dealt with fairly if they do.
Did you plead guilty to some charge?
I believe back then it was wire fraud, yeah. And it was basically I explained how the system worked to them, and I think they benefited from that.
You should know, Mr. Gold, my understanding is the file is sealed, and none of this is a matter of public record. I would expect you to treat the record appropriately on your own motion.
Certainly.
My understanding also is, and I could be wrong, that he was given an ACD, which is an adjournment contemplation of dismissal.
Which is the what, sir?
An adjournment contemplation of dismissal, or the equivalent of it, so that the record was sealed and charges against him were dismissed.
I've not seen, because it's not public knowledge, what the record is. So again, I would ask you to deal with this transcript appropriately. I didn't want to get put into the position, Mr. Goldstein didn't want to be put in the position of having not to answer any question you raised, though the fact that the file is sealed, it seems to me, is of significance.
Just so that we understand this clearly, I gather what you're asking me is to show this only to the lawyers working on the case, and including lawyers at MPAA working on the case.
No, I'm asking you to use your judgment as to how you deal with this approach.
Well, let me tell you what I think I'm going to do, because we'll send the transcript to lawyers for the companies, to lawyers for the MPAA, and to lawyers here, and we'll use it in court. Is there anything about that you find inappropriate, so I can consider it?
I will take it under advisement.
Yeah, we'll designate the ordinary court.
Right.
Just tell me what you mean and what you want, and if it doesn't block me from what I'm doing, that's what I'll do. That's all I'm asking. I have no interest in anything else but this case. When you use the word hacking, what does that mean? As you use it, sir.
My definition of hacking is basically a form of asking a lot of questions, experimenting with technology, basically twiddling with something until you get it to work just right. And hacking can encompass any number of things that are in your own house, things that you encounter on a day-to-day basis.
So it doesn't necessarily involve breaking into somebody else's computer system.
Not at all. That's a media definition. That's how the media has distorted the word over the past decade or so. But the real world of hacking, I think if you go through our pages, you'll see that it encompasses quite a bit more, not just things like that.
Well, what would it include, if you can give us an example?
Well, for instance, your own computer. There's a world of things you can hack in your own computer. Your own telephone. There's ways of figuring out how to dial certain things. It's, only simple-minded people think it's just to get a free phone call. No, there are things hidden within the switch. For instance, there's a number you dial to read back your phone number, and it's always considered a triumph when you figure out what number that is. To most people, hacking is a big waste of time because there is no immediate payoff. And that's something only people who are hackers understand, the thrill of figuring something out. I should say also a lot of journalists have the same thrill when they figure something out, when they chase down a source or uncover something no one else has uncovered. So I think the two are very tightly combined. And the fact that I'm both a hacker and a journalist, there's a lot to talk about.
Is the next chapter a regular piece in all issues of 2600?
You mean an editorial?
Is that your editorial?
Yeah, the editorial is always the first thing that appears after the stat box.
And you write all of the editorials?
Yes, I write the editorial.
Do I take it as far as you know? All statements made in your editorials are true?
It's my opinion.
Based on your information and belief?
Based on my opinion as a journalist, what I say is true.
Well, when a journalist calls Bush a crook, when a journalist says that Clinton is a felon, it doesn't necessarily mean adjudicated a crook or adjudicated a felon.
That was very interesting, Mr. Gorbis, but could I respectfully...
Gorbis.
I said one. But if I can, Mr. Gorbis, may I just on this record just ask questions to your witness and have him answer it, and have you withhold all of your learning about whatever it is? Is it your belief that journalists have any special exemptions from the law that applies to everyone else?
No.
Can I see that? Thank you, sir. Reading a sentence at page 6, right-hand side, in the second full paragraph, there's the second sentence says, referring to, well, the paragraph begins, the MPAA is coming at us using a very scary piece of law that civil libertarians have been wanting to challenge since its inception. Do you see that? It's,
yes.
Yes. What is it that you mean when you say civil libertarians have been wanting to challenge? What is it they've been wanting to challenge?
I object. It says what it says. You haven't interpreted it. You wrote it.
Basically, it's Digital Millennium Copyright Act that civil libertarians in the Electronic Frontier Foundation, as well as the ACLU, have been wanting to challenge, and I believe now they're challenging it because, I'm not a lawyer, but as a journalist, I see problems with the way it's written and with basically ways it can be abused.
What are the problems that you see?
Well, for instance, this whole thing here is based on an interpretation of the DMCA, which I don't think was the intention of the people who wrote the DMCA.
Which part of it?
Basically, that would make someone subject to lawsuits if they figure out how something works. It seems to me to be something that's a pretty ingrained part of our society, where you're allowed to talk about things, figure things out, spread information. We know theft is wrong. We know taking something that doesn't belong to you is wrong, or misrepresenting yourself is wrong. But that's not what this is about. This is about figuring out how technology works and being told that that's wrong. And that's where I have a problem with it. But again, I have to stress, I'm not a lawyer. I'm speaking as a journalist. That's my opinion on it.
Are you involved in figuring out what DeCSS means?
Well, in addition to not being a lawyer, I'm also not an engineer. I know many people who are engineers, and I respect what they do, and I believe I defend what they do in my pages.
Who is it? By name, if you can, if you know. Who is trying to figure out what DeCSS means?
You mean who is trying to...
Object to the formal question. I also object to all these questions of corporate legal conclusion. The witness is stating his opinion as a journalist about his position in this lawsuit.
Do you mean that is
not his position in the lawsuit?
No, I thought you said position. I thought it was possible. Okay.
Do you mean who's trying to figure out CSS? Because DeCSS is pretty much figured out.
Trying to figure out CSS. You're right.
Well, a lot of people, like I mentioned, people in the Linux world, people I believe in the Livid project as well, although they were basically trying to create a Linux player. A lot of people have gotten very interested in how encryption works over the years. Encryption is a very important thing. It's our key to privacy. And it's traditional in the hacker world, when encryption goes bad, to tell people about it, because that way the next bit of encryption is a lot more secure. And I think also what you're seeing here, a lot of people think it would be wrong not to tell people when encryption doesn't work, as is the case with CSS.
And in the last answer that you gave, when you used the word, I'll quote, a lot of people, what did you mean?
A lot of people in the community, in the Linux community, people on public forums such as Slashdot, basically people on the net who know what they're talking about. People who run businesses, people who are engineers, scientists, you name it.
Do you know how many?
Thousands.
How do you know that?
I see the posts. We talk to these people at meetings, at conferences. It's a lot of people, and also a lot of people who don't have knowledge that understand the journalistic implications here. So it's really helped us reach out to a lot of people.
In the second paragraph of the same paragraph, in the second sentence of the same paragraph, you wrote the following. It's called the Digital Millennium Copyright Act, and it basically makes it illegal to reverse engineer technology. Is that your understanding?
That's my understanding based on this lawsuit.
You think that's what this lawsuit is about?
It appears that way to me, that because DeCSS was written for reverse engineering purposes. So if that's found to be illegal, then under the DMCA.
The next sentence says, this means you're not allowed to take things apart and figure out how they work in the corporate entities involved. If the corporate entities involved don't want you to. Is that true?
That's based on my previous thought, that if that is in fact proven to be the case, then yes, that's how it would be decided.
And that's what this lawsuit is about, as far as you know?
That's what it looks like to me, yes.
Monthly 2,600 meetings?
Yes, we meet on the first Friday of every month in cities. In fact, if you look on page 58, it's a list of all the cities we have meetings in around the world.
And when you say we, who are you talking about?
2600, the magazine, very loosely based group of people that have similar ideologies on things.
And these meetings are held where?
Various public gathering places, for instance, in New York, in the lobby of City Court.
And who comes to them? Subscribers through 2600?
Everyone is welcome. Basically, subscribers, passers-by, businessmen, kids, governmental agents, you name it. We get all kinds of people.
Are these meetings, are any minutes taken of these meetings?
No, perhaps meeting is the wrong word in this context. Gathering is probably a better word for your understanding. There is no agenda. There's no one person speaking to everybody. It's kind of, we think of it as kind of similar to what the internet world is like, where everybody has an equal voice. You talk to whoever you want to talk to. If you want to be anonymous, you be anonymous. But basically we respect each other. We don't break any laws. We basically exchange information, talk, learn about things. So we've been having meetings since 1987.
It would be correct to say that everybody comes to one place and sort of hangs. Is that what you mean?
Pretty much, yes.
Yeah.
Gathering.
No speeches?
No. Not that I know of, anyway.
What reverse engineering purposes was DeCSS written for?
By reverse engineering CSS, it became possible to make DVDs playable on other operating systems besides Microsoft, Macintosh, both for operating systems like Linux and future operating systems that have not yet been written and may not have ever been written, because if your operating system can't do something basic like play a DVD, it's not going to be very popular.
How was DeCSS cracked? I'm sorry, how was CSS cracked?
Again, I'm not an engineer, but my understanding is that one of the companies that was licensed hadn't encrypted their copy of CSS, which made it possible to reverse engineer it based on that. So it was basically their responsibility that led to this.
So the fact that is it true the fact that it was cracked didn't relate to how strong or weak it was?
It still had to be figured out after that. It probably made it easier, the fact that they didn't encrypt, their copy of it. But our basic view is that any form of encryption will eventually be cracked, and you have to live your life realizing that and always be prepared to improve your encryption.
And is that why you say that CSS was a weak system?
That's not what he said.
That's not.
I asked you a question.
That's not why I say that. I believe CSS was weak based on what I've been told by engineers. I think it would have been cracked whether or not that company had an unencrypted copy or not.
It would have been cracked sooner or later.
Sooner or later, yeah, as any encryption will be.
How long had CSS existed before one of its users didn't encrypt a DVD with it?
Just one question for you testified in 97. With your questions, you can ask questions. No respect must be go around to understanding technology.
Who cares what you think? Don't be impolite. I find it very offensive. I'll take a test with you sometime after the case is over. Is that the sort of competition you have in mind?
Maybe you could read back the question. I kind of got distracted.
How long did CSS exist before one of its users didn't encrypt a DVD with it?
Well, CSS existed ever since DVDs were released, from my understanding. And again, I'm
approximately how long?
I'd say DVDs were probably released, I think, around 95, 96. Again, I'm not entirely certain about this, but and also I'm presuming that the company, I believe its name is Xing, Xing, hadn't been encrypting all along. So that may or may not be true, but that's my understanding.
So CSS was out there for 4 to 5 years before it was cracked?
It may have been. again, this is not something that I'm an expert in. They may have been a fairly new company that had just started using it, and maybe they were only doing it for 6 months. I don't know the facts in this.
Is the fact that CSS was being used for 4 to 5 years and then it was cracked in the way that you've described a reason why you say that CSS is weak or was weak?
I object to it. That's not what he said. That
That's why I asked him, is that true?
You're misstating it.
Could you read the question back to the witness?
Do you understand the question?
Read it back again.
Do you understand it? Do you want it read back?
Yeah, read it back.
Is the fact that CSS was being used for 4 to 5 years and then it was cracked in the way you described a reason why you say that CSS is weak or was weak?
I'm not certain it was being used that long, and I'm also not certain how long it existed in an insecure state so that it could be cracked quicker. I also don't know how long the people were actively trying to do this. While DVDs were released several years ago, DVDs on computers are a fairly new phenomenon. So I don't think very many people in the Linux community would be trying 4 years ago to crack this. But I think once they set their minds to it, it wasn't very difficult.
But they didn't do it without someone failing to encrypt.
That helped. I don't think that would have prevented things in the end.
What do you mean by, quote, in the end?
I think it would have, for one thing, the encryption was developed in a closed environment. If you want good encryption, you develop it in an open environment so people can test it before it actually goes on the market. CSS was developed so that nobody really knew the equation, and thus they didn't have a chance to really test it amongst the people who would figure it out. So I think that was a big disadvantage that they had. And that's something the open source community has always supported, is openly developing these things. So ironically, they would have had a more secure encryption standard had they consulted with these people.
Off the record.
I'd like to have this marked as plaintiffs 3, I think we're up to. Is this a news story you wrote and put on the 2600 website?
Just trying to determine if this is one of the ones I wrote. I definitely approved it and put it on the 2600 website.
Well, take your time and read it and see if you wrote it. I don't think it's appropriate to talk to the witness, Mr. Gorbis, in between a question and an answer.
I believe this is one of Mackey's. It's based on their phraseology.
And it was Mackey?
Mackey's our webmaster. But I read this and approved it.
Did you believe it true when you read it?
I believe it true when I read it, yes. There are a couple of technical issues here that have since been proven to be inaccurate. I think that goes to show that even we didn't have a complete understanding of the technology at the time.
What in the article what in this article
There's
now believe was incorrect?
There's one part here, I think it's the third paragraph down under the date, where it says that this facilitated the copying of DVDs. Again, it's the nature of the net when something is released that people don't always have the complete facts. And when we researched this more afterwards, and you'll find this in later news articles, we realized that it was not about copying DVDs. We were kind of taken in at the beginning, too. It's not about that at all.
What sentence were you reading?
I'm reading the first sentence in the third paragraph.
As a result, they were able to create a DeCSS. They were able to create DeCSS, a free DVD decoder, that not only facilitated the creation of previously unavailable open source DVD players for Linux, also allowed people to copy DVDs, period.
Right.
Are you now saying that any part of that sentence is incorrect?
The last part of that sentence is incorrect because as we later...
You mean the also allowed people to copy? Well, is it a fact that the free DVD decoder that you talked about at the beginning of the paragraph, in fact, did allow people to copy DVDs.
No, the fact is that DVDs have always been able to be copied. The only thing that DeCSS does is allow them to be played on a different platform.
And it's your testimony that DeCSS does not decrypt?
DeCSS does decrypt. It does not make it any easier to copy. It allows you to be able to view it on the platform of your choice.
When you decrypt DVD, is a copy made on your hard drive?
I've never used the program, so I don't know if a copy is made on your computer. I don't know anybody with the size of a computer that would be able to hold an entire DVD. It's incredible.
What you're saying is you don't know whether or not a copy of the DVD is made when you decrypt it on your hard drive.
I don't know for sure. I think it's irrelevant because,
Before we get to the irrelevant part,
okay,
how can you say that no copies are made unless you know that DeCSS does not put a copy on your hard drive when you decrypt it?
I object to the form of the question. You misstated this testimony, not understanding technology. I'll allow the witness to answer the question if you can.
I'll try to explain this. Basically, copying of DVDs has been going on since virtually day one. When you copy a DVD, you're copying something that's encrypted, and as long as you have a player, the player doesn't care if it's a copy or if it's the original. Whether or not you copy something that is unencrypted onto your hard drive or encrypted, it doesn't make any difference. If DeCSS allowed you to copy the unencrypted file onto your hard drive, it's no different than copying the encrypted file onto your hard drive, because what CSS did was decrypt that. All you needed was a valid player, and that would allow you to view an encrypted file. So, again, I've never used it. I don't know anybody who has used it. I don't know anybody who would have the hard drive space to hold an entire DVD. But even if it was possible, and I stress if, it wouldn't make a difference because you could still play an encrypted DVD using a valid CSS player, as has been done for years.
But you've got to first decrypt the DVD, isn't it?
CSS decrypts the DVD.
Right. Do you believe that that's true?
Yes, that's the purpose of it. It's in every DVD player, whether it's on an operating system, whether it's a standalone unit. The copy of CSS that's in there is what decrypts the DVD, and that's why I say that if you make a bit-by-bit copy of an illegal DVD, like say from Asia or something like that, as has been done for years, it's not going to know the difference. It'll see the encryption and decrypt it, whether it's a copy or the original. And that's why I say it's irrelevant whether or not you have an unencrypted copy on your hard drive, because you could still just as easily, even easier in fact, decrypt an encrypted copy.
So then I take it you don't know one way or the other whether when you decrypt a DVD, a copy is put on the hard drive.
I don't know, since I've never done it.
Now, at the end of that same paragraph, there's a reference to, quote, antiquated encryption export laws, close quote. What does that mean?
I believe that refers to the fact that there are strict limitations on encryption that we export from this country, and because DVDs are exported overseas, an artificially weak encryption was used.
Because of this law?
Because of a law, I'm not sure which law it is,
right,
that considers encryption an armament and makes it so that you have to
considers encryption what?
An armament. Yeah, and basically force them to encrypt in a rather weak state, something I don't think anybody who knew what they were doing would be happy with. And that, of course, led to it being cracked a lot earlier.
On the same document, sir, the last sentence on page 1 begins, quote, that is why we feel it's necessary to preserve this information, period. We do feel sympathy for the DVD industry now that their encryption has been cracked. Perhaps they will learn from this. Close quo. What learning did you have in mind?
Well, it was our hope that they'd go on and come up with a better way of encrypting DVDs and learn from the mistakes they made and not continue to go after people. And I should stress that this article is before any papers were filed against us. Obviously, they didn't follow that.
So do you feel, or do you believe that the use of part of the use of DeCSS is to teach the movie companies that they've got to make tougher protective devices around their copyrighted work?
I don't think anyone went out and said, let's teach them a lesson. I think basically this is something that happened in the natural course of things, and I think it's an opportunity to learn that's being wasted.
Is the export law you talked about in the preceding paragraph still in effect?
Again, I didn't write this article, and I'm not an expert on law, but I do recall hearing sometime in the recent past that Clinton relaxed some export regulations.
And that may or may not be one of them.
It might be.
I see. Do you consider yourself a hacker?
Yes.
Did you or any other hacker you know contact
the way he defines hacker?
The way I define hacker, obviously.
In other words, when he's defined hacker, he considers himself a hacker.
Which shows that you were listening. Did you or any other hacker contact the movie industry or Matsushita or the DVD-CCA to discuss the findings of the DeCSS creators? The question was, did you or any other hacker you know of contact the movie industry or Matsushita or the DVD-CCA to discuss the findings of the DeCSS creators?
Back when this happened, which was early November of 1999, I had never even heard of the DVD-CCA, so contacting them wouldn't have even come to mind. We were reporting this as journalists. We were reporting facts. The facts were this happened, this was cracked, and that's what we printed on our pages, that it was cracked.
But if a purpose of the cracking was to teach them that they had to make a stronger protective mechanism to protect their copyrighted work, why wouldn't you or someone else involved with DeCSS call them and tell them that?
I imagine they were contacted.
I'll object to the form of the question. The New York Times printed it, the San Jose Mercury News printed it. To my knowledge, no newspaper reported it as not dysfunctional.
I didn't get the answer if there was one.
There was one.
I couldn't quite hear it.
No surprise. Read the question and let the witness answer it again.
But if the purpose of the cracking was to teach them that they had to make a stronger protective mechanism to protect their copyrighted work, why wouldn't you or someone else involved with DeCSS call them and tell them that?
I believe I said I imagine they were contacted at the time.
By whom?
Well, at this point, it was pretty widely reported throughout the internet, so for them not to know about it, I think, would be very unusual. But again, we were reporting something that happened. It wasn't our place to go around and make sure that everybody knew about it. It was a fact. We were reporting it. We weren't involved at that point. It was just something interesting that we were following.
At the beginning of the deposition, or maybe before it started, I asked you which name that you would be comfortable that I used, and I think you told me Emmanuel Goldstein.
I actually said either name is fine. Emmanuel's name I'm known by most people.
And what is your legal name?
Eric Corley is what I was born with.
Eric Corley is
C-O-R-L-E-Y.
And you never officially changed it?
No, that's still my legal name.
I gather there's no objection here with respect to the fact that he wasn't sworn as Mr. Corley, he was sworn as Mr. Goldstein. It's fine. Okay. Were you raised raised in New York?
Yes.
Which high school did you go to?
Ward Melville High School in East Setauket, New York. That's Setauket.
Did you attend college?
Yes. State University of New York at Stony Brook.
And what did you major in?
I was an English major.
Did you attend school after you graduated?
No, I did not.
Did you graduate?
Yes.
And did you begin working? Did that come time you began working?
Yeah, I worked in numerous capacities for newspapers.
Which newspapers? And to the best you can, what dates?
Well, I worked for a newspaper on campus known as the Stony Brook Press, both as an unpaid writer and a paid typesetter. And then I continued working as a typesetter for a local community paper known as the Village Times. And that's when I began publishing my own publication as well. And the rest is pretty much history.
Do you receive remuneration from 2600?
Yeah, that's my full-time job now.
And is that your sole source of remuneration there?
Right now, yes.
And is it correct that the Village Times and then your own publication are the two jobs you've had since graduating?
Going back a long ways. So I believe so. I believe that's where I was working right after graduation. I mean, I had part-time jobs before then, but as far as I know, that's what I had afterwards.
And your home address is what?
7 Strongs Lane. That's Strongs, also in Setauket.
And I gather your business address is in the magazine somewhere.
Yeah.
In this 2600 hack report.
Yeah, on page 3, I think.
When was 2600 Enterprises Inc. incorporated?
To the best of my recollection, in 1984. I don't have the specific date.
And it was incorporated in New York?
In New York, yes.
Who were its directors at present?
I'm the sole proprietor. Sole owner.
There is no board of directors?
No, there is not.
And are you the only officer?
Yes.
Does 2600 Enterprises have any employees?
We have an office person who enters subscriptions, and anything else is strictly on a per job basis, such as if we hire an artist to design a T-shirt, if we pay a printer to print a magazine.
Have you had the same printer for several years?
Yeah.
And who's that?
Portside Graphics in Port Jefferson, New York.
And what's the name of your office person?
Her name is Mary. Last name Nixdorf, Nixdorf.
Does 2600 have any function other than 2600, than issuing 2600, the Hacker Quarterly?
We publish a magazine. That's what we do. Things happen along the way, such as having 2600 meetings, but the magazine is really what we do. Even the website is something that just evolved. As a result, we make no money off the website. It's just a project that a bunch of people engage in because they want to become involved in that part of technology.
Are there other websites around the country that are affiliated with you?
The only website affiliated with us is our website and one for the upcoming conference known as h2k.net, which is also h2k.net. It's on the same machine, so it's really the same thing.
Is the Hacker Quarterly put in its entirety on your website?
No. The website is a supplement of the magazine. It's not a duplication of the magazine.
Well, each quarter, do you put selected portions of the Hacker Quarterly on your website?
I'd like to, but unfortunately we don't have the staff to sit around scanning and posting, so right now, no. We'd like to in the future.
So is it rare that you ever put anything that's in the Hacker Quarterly on your website?
Use the word rare.
Well, I don't think we've ever duplicated anything other than the covers on the website. Not to my recollection.
Except in this lawsuit, have you or 2600 ever been accused of violating anyone's rights in connection with a hack or in connection with the material that you published, other than this 1984 thing that you testified?
Do you mean have we gotten letters saying that, threatening letters from lawyers, or have we actually been brought up on charges?
Have you actually been brought up on charges?
No.
Have you got threatening letters from lawyers?
We've gotten a few on occasion.
How did you get them on the...
They were sent to us in the mail. And
do they exist now?
I'm not sure what you mean, do they exist now?
Do the letters exist?
They might be filed someplace. I don't think I can ever find them. We usually print them, so you can find them in the magazine. But nothing up until this point has ever gotten past the first step of a nasty letter being sent.
How many issues of this magazine have been?
Well, we've been coming out for, I guess, 18 years. No, this is volume 17, so 17 years. So
17 times 4 would be...
We've been quarterly since 1988. Before then, we were monthly. So you'll need a calculator.
And is it your testimony that you published all these threatening letters from lawyers in one of these issues?
If we got a letter that we thought was particularly unjust, yeah, it's been our policy to show people the kinds of threats that are being made against us.
I'm going to ask for copies of all back issues of 2600 and any of the lawyer letters that Mr. Goldstein might have around his office or in his files.
I'll see them.
Now, what exhibit are we up? I'm sorry.
Can I just clarify? Do you want all back issues that have lawyer letters published?
No.
No, it's all back issues.
All back issues.
And any letters that we have. Is that right, Mr. Lewis?
That's right. That is right.
Can you take it under advisement?
And this mark says exhibit. What are we up to, sir? 4. If you can take a minute to look through that. I guess we'll change the date while he's looking.
Okay, Mr. Gold, I don't know your schedule. As I said, we be prepared to go through lunch because I know you want to finish the deposition. We'd also be prepared to work until 5. Again, subject to your convenience, or even work later in the evening to try and give you as much as you can.
You know, we've advised you that the deposition would be today and tomorrow. I think we'll finish tomorrow. I doubt we'll finish today, and I do feel that the judge, having called a conference and been kind enough to put it at the end of the day, that I should attend it since I have been involved in writing a few letters to him. And the judge might be interested in talking about one or more of them. I think it would be improper for me not to be there.
Do I have somebody else take over the deposition?
No, I think I'll stick with what I noticed, which was today and tomorrow, and the rest of it I'll finish tomorrow.
I think that you wrote letters, but I don't think the judge will be interested.
That need not be on the video.
The time is 12:28 p.m. This completes tape number 1 of the videotape deposition of Mr. Emmanuel Goldstein. The time is 12:34 p.m. This begins tape number 2 of the videotape deposition of Mr. Emmanuel Goldstein.
Mr. Goldstein, have you seen the document just put before you before today?
Yes, I have.
And when was that?
I believe it was 2 weeks ago.
Did you understand at that time 2 weeks ago that a call for the production of documents?
Yes.
Did you make any search for the documents requested?
Yes.
Tell us everything you did to search for the documents requested.
Well, I searched through a pile of papers in the attic and tried to find as much as I could. Contacted my accountant, got together the back issues you requested. I think that pretty much covers everything. Now, I also searched the computer system that I'm on for any email that may have been there or any logs.
Did you throw away or dispose of or take out of your hard drive any documents at all from the time you saw this particular document?
No.
Did you find anything?
My webmaster found a couple of logs. I believe he forwarded them to our legal team. As far as on the computer system, I searched, I grepped for DeCSS.
You did what?
It's
grepped?
Yeah, GREP. It's a Unix term. To my email for anything to do with DeCSS or DVDs, and there was nothing there. I assume anything I get in the future I'm supposed to forward.
The documents you found you gave to your counsel?
Yes.
Mr. Roberts, do you know if those have been supplied to this office?
I don't know what's going on with Mr. Hernstedt and you. I presume Mr. Hernstedt gave you whatever Mr. Goldstein gave him.
No, we haven't received any documents.
I'll find out. I can't do that time. Hernstedt's gone. Whatever Mr. Goldstein gave us that's appropriate, we'll certainly give you.
Did you, Mr. Goldstein, when did you give these documents to your lawyer?
I know all my financial records arrived last week from my accountant. As far as the things from the website, I know our webmaster has been in touch with Marty and Ed on that.
In touch with them?
Marty and Ed, our legal team. And as far as anything else, I don't think there was anything else I can recall.
I had understood we had furnished you with approximately 200 to 300 pages of information that is similar to the information that had been in Mr. Goldstein's affidavit on the motion. I had understood it was even sent to you by separate letter. We can check that with Mr. Hernstedt.
Okay, because as of last night, no one in this office on the team had received any documents. But I appreciate you checking.
Mr. Goldstein, do you know any reason why your attorneys wouldn't have turned those over before today?
I know that my accountant had been away and hadn't gotten my message until last week, so he wasn't able to FedEx the documents until late last week. So that might be a reason for that. Also, I brought in the back issue request too. I brought those in today, actually. So that's my fault.
Turning to page 7, number 1. What documents exist relating in any way to the 2600.com site?
I'm not sure exactly what documents you had in mind. Again, it was something our webmaster was dealing with. As far as documents that are on the site, we're prepared to give you an entire snapshot of the site, which would be every page that is there.
And that would include pages relating to what issues?
Well, the site is not having to do with the issues. The site is a website. That would include all the news articles ever written on the site. That would include... well, it couldn't include the radio shows that we have up there because that's an audio format, so I don't know how that would work. Basically, a lot of documents related to this case, a lot of documents not related to this case. That's what you want. We can furnish you with those as well.
And now, when you saw this document and didn't understand what it meant to ask for all documents concerning the 2600.com site, did you put in a call to your lawyers?
Yes, I talked to my lawyers. I also talked to my webmaster and told them to work it out.
And did your lawyers tell you what it meant?
I believe so. I believe it was basically...
any conversations between Mr. Goldstein.
What did your... I don't know that this is instructions on how he was to make the search. I think are not privileged.
I think the judge should be able to.
You don't know that rule.
I think the judge should rule on it. I think we may disagree.
Are you saying that those are privileged?
I'm saying there's a conversation about documents, then some of it may be privileged, some of it which is just functional may not be privileged, but there may be privileged conversations within that. I would exert the privilege and then you can get a ruling.
I'm just trying to find out what the witness was told about what documents to produce.
I presume he was told he was everything he could.
Yeah, everything I could on the website, except there's one big omission. They say all files made available for download from October 1st, 1999. You do realize we can't give you DeCSS because that's no longer on our site.
You say that when you didn't understand what you would have looked for with respect to number one, you called your lawyers.
I don't know if I said I didn't understand. Just I wanted to make sure that I understood correctly that it was basically a snapshot of the entire system, which is no problem at all.
Did you give that to your lawyers?
Again, that's something our webmaster would do because he has much better technical knowledge.
I presume he's told you to ask.
Yeah.
So when did you tell your webmaster to produce those documents?
That was shortly after I got this document.
So where were they, or have they been produced to your lawyers? Where are they?
As far as I know, they have been produced.
Those are the approximately 300 pages that you were...
I don't know if it's 300 pages. It's a lot of pages. I'm not sure exactly how many.
I see. So did your lawyer define for you what number one...
I just say so you'll get everything that...
We're waiting.
That he can down.
We gave you over 10,000 documents and you complain it isn't enough, even though you haven't read it 10 times. And we asked you for a couple of documents and they're not here.
Mr. Gore, you've made your record.
What?
You've made your record.
What does that mean?
My understanding is that...
I know what your understanding is and I know what you're doing.
Good, so let's go on.
Okay. Now, did your lawyer give you any description of what you should produce with respect to item number one?
I think I already understood what I had to produce. I think you wanted...
Then why would you have called him to ask him what it means?
To clarify that I understood correctly that...
Did you do that with number two?
Number two.
Did you clarify what your understanding of number two was?
Well, number two is documents that grant us the right to copy motion pictures. I know we don't have documents that tell us we can copy motion pictures, so I don't see a need
what
to ask.
number two was, and you didn't have to ask anyone. Is that right?
Well, it was pretty obvious that those documents didn't exist.
Well, when you knew what one meant, and since you knew what it meant, why did you have to ask about it?
To clarify, to make sure that you wanted a copy of everything on the site, and that's what we were going to do, and that I was going to ask the webmaster to provide you with that. You should understand that the people who work on our site are basically in school, and sometimes they're not easily reachable. We've tried as hard as we can to get these documents, and we wanted to be thorough. We wanted to make sure we didn't just give you a couple of things. We wanted to make sure you got what you were asking for.
So does that mean, with respect to number one, you have not yet finished contacting all of the people you want to contact?
There's one person, and I've contacted that person. That's our webmaster.
Well, what about all these people you refer to who work after school?
I'm saying people who I'm in contact with, and the webmaster is one of them, or people who are not, they don't have full-time jobs with our site. So I have to find where they are. I have to email them. It might be a couple of days before they get back to me sometimes, but it is our intention to get you every document you asked for.
Have you already done that?
As far as I know, that has already been submitted, as far as I know.
To?
I believe it's been emailed over to the legal team.
Your legal team?
Yes.
Who is on your legal team, other than Mr. Gorbis and Mr. Hernstedt?
Those are the two names I know. I mean, I know there are more people working on the case.
And is it true that 3 would have been a part of number 1 that you've already produced?
Yes. That's something that I would have immediate control over because you're asking within my possession. And so I did that search on my system where I get my email.
Well, it would relate to you or the company.
Mm-hmm.
Yes. I gather.
Right.
And you've searched for any possible documents around.
I searched them throughout my email.
For the company.
Well, if you mean did I search other people's email, that doesn't belong to the company.
What does the word other people mean in that?
We have, the system 2600.com is what's known as a shell machine. It's used by people who write articles for the magazine. It's used by people who are affiliated in one way or another, whether they do covers, they're artists, they're writers, they help us out in some way technically, and they each have an account on the machine. And they receive email there, they have their files there, and it's not our position to claim ownership over those files, over that email. I know many companies do claim ownership, and we just don't subscribe to that philosophy. So the way I took number 3 to mean is that I should look through my possessions, my email, my files, for anything having to do with DeCSS, which is what I did.
Can you name the people that you refer to?
Not all of them.
Well, name as many as you can, sir.
We're talking several dozen people here. I mean,
take a shot.
I can give you usernames of people, but I can't place names to them. I mean, is that enough for you? Because the way our community...
What's the username?
Our username is what you log in as. For instance, my username is Emmanuel. All right.
Why did that custom go? Why don't people use their real name?
Well, for one thing, the way the system is set up, you can't type in a full name. The way the net works, people choose handles. And basically it's your identity on that particular computer system. You may choose a different identity on a different system. You may use the same identity everywhere. You may use your real name. People do a lot of mixing and matching. What I'd be happy to do is give you a user list on our system. That's not what you asked for, so I didn't provide that. But if that's what you want, I'll happily give you that.
Thank you. We are requesting it.
Sure.
And all those names would be on that list?
The names of the logins. You have to understand, I don't even know a lot of people's names. I don't need to know. I don't ask. But what I can give you is, this sounds like something it's not, but I can give you our password file, which basically is a list of all of our users. It doesn't contain the password. It contains the encrypted password, which is a good form of encryption, I believe.
There seems to me a press issue here as to exactly what is turning over and whether a member of the press should be required to turn this over. I'll just take it under advisement. I haven't pulled out the ramifications of it.
The part-time people that work for 2600 and who go to school during the day, how many of them are there?
Well, there are lots of people. I wouldn't say they're part-time employees or employees in any sense. They're volunteers, people who help out whatever way they can, whether it's writing an occasional article or submitting something of interest to us or advising us in some way. There are people from all different age groups, all different parts of the world. It's impossible, and I don't think desirable to know exactly who they are, where they are, what their Social Security number is. It's not what we're about.
Do you pay any of them?
The only people we pay are the office staff and the people who do things like design covers or print the magazine.
Well, the office staff consists of one person?
One person, yeah.
Okay. So you don't pay any of these part-time people?
No, we don't consider them part-time people. We consider them volunteers that do what they can when they can.
And do any of the volunteers live in the greater New York area?
It's possible. I mean, I imagine so. Yeah.
And do you have these volunteers listed somewhere? However you list them?
We have a staff list, which we put in the front of the magazine, and that lists writers. You can get a pretty good sense of who volunteers there, what they do.
That would constitute about, in any one issue, about what percentage of the volunteers?
Actually, that's probably more than the people who volunteer at that particular time. I mean, at any one time, for instance, we have a conference coming up in a month. We have a few dozen people who are going to be working different things, whether it be hooking up a network over there, running security, doing various other things that you have to do when there's a conference. Nobody's getting paid to do this. It's something they all want to do. That's something that happens at this particular time because we're doing a conference. What happens in the fall will be completely different. We'll have people who write articles, people who submit various things to the magazine, people who let us know what's going on, tip us off on a story.
And the names of every one of these people is listed in at least one issue of your magazine?
The names they want to go by, yes. We don't require that they give us their real names or that we even know who they really are. It's not our place.
Why not?
We're a magazine. We print information, and that's where we draw the line. I mean, if somebody wants to be, known to us, then they'll introduce themselves to us. But we're not going to force our way into people's lives and demand to know who they are.
So the New York Times and the Sacramento Journal and all other publications that I know about know who works for them. They have their names. Why wouldn't you?
We're not the New York Times. We're a magazine dealing with technological issues. Lots of times articles are written by kids, by people from other countries. We don't run our operation the same way as the New York Times or as many newspapers or magazines.
Well, what if they... I'm sorry, did I cut you off?
Well, we allow people to use what I described before as handles, which is basically you make up your own name. You define yourself, and that's perfectly okay with us. A newspaper like the New York Times, obviously, they want your real name because they're paying you. They have to have all your documentation, your social security number, all that kind of thing. And that's perfectly okay, but that's not what we do.
Well, some of these no-named or fictitious named people that volunteer write articles, don't they?
Yeah, some people do.
Yeah. And wouldn't you want to know how to find them in case you had a problem because they printed something that was a total lie?
Well, that's why for someone who writes more than one article, we give them an email address in our system. So that's how we contact them.
And you have a list of those email addresses?
That's what I was describing before.
And you're going to provide, can you provide those?
I can provide you with a list of the users in our system, yes.
And you say you're not interested in the name of anyone who just writes one article for you?
No.
I see. Is that true or false?
I'm not interested in anybody's real name. It's not relevant to what I do. We have people who write letters to the editor, and we don't consider them staff people, but it's something that appears in the magazine as well.
Well, other than letters to the editor, if someone writes a story for you that you print, but they only write one, you don't want anything from them, any way of finding them or contacting them? Other
than an email address? There's no need. We give people who write to us a free subscription. So that's basically what we do.
So a one-time author, he's lost forever?
If he doesn't write to us again, yeah.
Isn't it true that you print the names of people who write letters to the editor?
We print whatever name they sign. So it's very rare you'll see somebody's real name signed to a letter.
That's sent to your publication?
Right.
Do you have any standard procedures you use to check on the truth of articles that you write in your publication?
Yes, it depends on the article. I mean, there are many different things, but we'll test things out. We'll make sure that the person knows something of what they're talking about, that the system that they're describing really exists, that the theories they're talking about seem to make some sort of sense. It's different with every article.
You don't check outside sources, just the writer?
I'm not sure what you mean.
Well, in terms of your diligence, when you're about to print an article, do you do any checking other than with the person who wrote
of course. Yes, of course. To see if they're describing a particular computer operating system, of course, we check to see if the operating system exists. We check to see if what they're describing, many times what people write is theoretical in nature. So we check to see if theory seems to be a valid theory, not necessarily whether it will work, but whether it's conceivable.
Now, have you written articles about any of the plaintiffs in the last 6 months?
Other than ourselves?
Have any articles or writing appeared in 2600 about any of the plaintiffs?
The editorial is what, and some letters to the editor.
Have you ever checked with any of the plaintiffs about anything you wrote?
I'm not sure what you mean.
You ever call them up and...
Have you checked with the MPAA and asked them what you're saying about...
No, I didn't say the MPAA. I said any of the plaintiffs. Those are the movie studios.
Right. Well, what I write is an opinion piece, so...
You don't check?
I don't think I have to check with somebody if I write an opinion piece.
Does your opinion piece ever contain any facts? Any statements of fact?
It contains my interpretation.
Of statements of fact?
My interpretation of facts, yeah. I consider that...
And you believe that they're right?
My opinion that they're right, yeah.
But they're right. And you have his answer.
My opinion that they're right.
Yeah. Well, did you ever try to contact any of the movie studios or MPAA about any of the statements you've written in the last year?
I haven't been writing about the MPAA for a year. I haven't been writing about the MPAA for a year, only since they filed suit against us. I don't think it's appropriate for me to be contacting them if they filed suit against me.
Who told you that?
That's my opinion.
So the answer to my question is no?
Have I contacted them? No.
Oh, simple. Actually. Truth is simple. Okay. Have a nice one.
I think Mr. Gold...
Off the record now?
Yeah, we will. So that...
It's back at 57 p.m. We're going off the record?
Yeah.
The time is 2:08 p.m. We're back on the record.
Mr. Gold, let me tell you, I had checked during the intermission. My recollection is we had furnished you with material that comes within point 1 that was accurate, namely that in the affidavit of Emmanuel Goldstein that had been submitted on the motion, we had furnished you, as I understand it, with all documents concerning the 2600 website as it existed since, I think, about November 12th. With respect to the other information, we are still trying to get that for you. But my understanding is that that information had been furnished to you a good while ago.
As an exhibit in Mr. Corey's affidavit?
Yeah.
Well, we have that.
Yeah. I'm saying that has been furnished to you. My understanding is...
Yeah, and this is a room with a table also, but now what about all the documents that the witness gave to you that you said you hadn't produced? Or that we
those Mr. Hernstad, as I understood, was furnished it to you, and you will get it by today or tomorrow. I don't know.
Do you know why it hasn't been produced for the last week?
I presume because Mr. Hernstad has been busy doing other things.
Instead of producing documents to us? Yeah, I would guess that. I just didn't understand what your statement had to do with the fact that you hadn't produced the documents we were talking about.
Because you have to understand that you have 90% of the documents.
How do you know? You've never seen them, have you? You're not
of course I have.
Of course I have. Okay. Mr. Otis, we would like to hire an expert and get access to the witness's hard drive for the expert to download certain things that Mr. Corey says you can't download. Mr. Goldstein,
I'll take it under advisement.
When will you tell us? Because I'd like to know tomorrow.
I'll try and tell you tomorrow.
Okay. We would, in doing that, we would only ask for the production of whatever relates to DeCSS and CSS.
So if there's nothing on the hard drive that relates to either of those two things, we don't have an issue. So the first question is whether or not there's anything on the hard drive. In other words, let's assume there's nothing on this hard drive.
We won't know until we get an expert in to...
In other words, you won't take his representation that there's nothing on this hard drive that relates to CSS or DCSS and may contain other information, some of which you clearly ought not to see.
He hasn't got any idea what's on the hard drive. He was trying to search
the first thing you should do is determine what's on the hard drive.
He said he couldn't do that. You weren't here.
I was here this morning. I was here.
Well, I mean,
I was here this morning.
actually.
We will take your request under advisement.
But what your witnesses testified to here was that he didn't feel he could pull down. That is a funny question. I join your laughter. Do you want to weigh how much time you took up today against how much time I'm taking up now? Your witness, as you know, testified this morning that he didn't think he could pull anything down from his hard drive, that he had tried before and couldn't do it, that it wasn't set up in order to do that. I found that surprising in light of what I read in the papers all the time about other people's hard drives, but I'm not a hard drive expert. So I wanted, so he said that he didn't think it could be done, and he had tried to do it. We want to get somebody in to actually see if that's true, and whether he can get something.
We'll take it under advisement.
Well, can I say something at this point? I get maybe 1,000 pieces of email a day. I'm not quite sure how somebody is going to go through all the deleted mail, which has probably been overwritten by new material since then over the past several months, and track that. I mean, it's not possible.
Well, that's
if it were possible, it would take you years, but I don't think it's possible at all.
Well, we'll take a crack at it if you permit us to. That's an unfortunate word, isn't it? We'll take a shot at it, and we'll see if that's right, and if there's anything that he can get out that's relevant, he or she, then we'll ask for its production.
As I said, I will take it under advisement. I'll try and make a determination. If I can make a determination by tomorrow, I'll tell you. If it requires something more than that, I will also tell you.
Okay, well, I hope we hear from you tomorrow. Now, I take it that all of the material you attached to one of your affidavits was material relating to sites that 2600 was linking to, not material related to 2600.
That's wrong.
I don't believe so.
I assume you're familiar with the affidavits we submitted to the case. That's wrong.
Well, in paragraph 5 of your June 14th declaration says, as I stated in my previous declaration in support of this motion, the sites containing DeCSS, mirrors to which we currently link, are very diverse in nature. In particular, many of these sites provide a variety of legitimate information concerning topics related to this case of DeCSS, and are thus more than just mirrors setting forth the DSS code. Annexed here too, as Exhibit C, are copies of the first page of the mirror sites currently listed on 2600.
Mm-hmm. That's a list. Not the entire site, but that's a list of the sites.
Yeah, but what we have in that bulky exhibit are copies taken from those sites that you link to, right?
I'm not sure. I haven't...
Yeah, this is what Mr. Barbas must be talking about. It may be, yet again, that he has committed an error.
Are there anything here from you, or is it just from the mirror sites?
That looks like, those are different sites. There's a list.
Well,
these look like samples from other sites.
At the end, what do you say now?
If I'm in error, I'm in error. In other words, if you're telling me that we didn't give him that, then we should certainly give you that. I had understood we had given that to you.
This looks like an indication that the sites are diverse in nature and have all kinds of other material in addition to DeCSS. I think that's the point of submitting this.
Right.
But was there another stack of documents?
I had thought there was. I had thought I had seen a set of documents which were everything that we had done from let's say November until now. When I say everything, I mean some of the 2,600 editorials.
Actually, I see it over there. I see that stack right there. Those are editorials. That's what we would have given you. It's really not that much. It's everything we've written on the website from November until now.
I thought we had given that to you. If I'm in error, you'll certainly get it.
Can you state for the record, perhaps again, what it is you think you've given us?
Be specific. You've seen this. If I am in error or if they haven't received it, don't get in that. Just describe what's in this package.
Is it all right if I ask the question? And without directions?
Well, but you're misleading the witness, Mr. Gold.
Yeah, but you shouldn't.
Go ahead.
You know how to object.
Go ahead.
And you shouldn't tell the witness what to say. You really shouldn't.
Mr. Gold, please. Continue.
As far as I know, obviously we gave you this, which is a description of various...
Did you give us that? Do you know that?
Well, from what you've told me today, yes.
Well, do you know that? You have it in front of you. Did you give it to us?
I remember we went through to find samples of other sites, but this was quite some time ago. This was a couple of months ago. I also know that we've gone through every single news item that we've written on the sites, and I presume that was submitted to you as well.
By who?
By our lawyers.
When did you give those to your lawyers?
I think we've gone through those several times, actually. I mean, we were trying to...
I don't know who the we is, sir.
Me, my lawyers, our webmaster.
I've gone through the stuff you wrote for your website.
The news items on the website, yes.
The ones you wrote?
The ones I've written and the ones that were written by other people as well.
So you say there was a group or a stack of papers that are pictures taken from or copies taken from your website?
They're basically just articles, yes.
They're taken from yours, and they're articles or editorials that you've written.
Yeah.
And then you gave them to your lawyers. That stack. Is that true?
We either gave it to them or told them exactly how to print them out. I mean, anybody can do this. You just go to the website and print.
Then I take it you're not sure you gave them this.
There have been so many papers floating around. I don't know if those are the ones that I handed to them or if I just said, this is how you print them out. But I know we've been over this.
Mr. Gold, let me just say one thing. Anybody can just go to the site and download it. My memory is that Mr. Goldstein told us how to do it. We did it, and I thought we had given those documents to you. If we have not, you'll get it. They're available to anybody who wants to get it.
I see them here, though. I mean, either we gave them to you or you printed them out yourself, so I'm not quite sure.
Something we printed yourself.
Okay.
But you don't remember, I take it, that you gave a stack of those stories or editorials to your lawyer?
I know we've gone through it at some point, and I'm fairly certain that all the papers have been submitted that we're supposed to submit. I can't give you a time and date of every single one we did.
Why are you so certain?
Because I've been going through this for quite some time.
But what does that mean they were given to us if you sat and went...
I'll object to this. This is totally unnecessary. I'll direct the witness not to answer.
You don't want to let him answer any more questions about the production?
No, I'm not going to let him answer that question. It's badgering him. He said he gave the papers to us. And what happens, whether the papers go from us to you or not, it's not something he should be badgered on. What I'm telling you is that it's my understanding we gave it to you. It's also totally on the public record. It's not anything that's being withheld. And you have indicated that you have some of those documents. Anybody can download it.
Are all those documents downloadable now, or are some of them lost?
No, we don't erase anything on our site. That's on the website.
What about the email? That's not on the
email is not on the website.
Right. I gather, Mr. Gorbis, you don't know whether those documents were given to us personally.
My understanding is that they were. But I could be wrong, and if I am wrong, you'll get the documents. But they're public knowledge. Anybody can get them. Nothing's been withheld from you.
Turning to item number 8, did you search for those documents?
Yes, this is the email that I grepped through and looked for any mention of those words.
And what?
I grepped and looked through any mention of these words.
And where did you look for them?
On my home system, 2600.com.
What's it called?
2600.com. But I should point out, I, as a rule, don't save mail. It clogs up the system. And as far as chat rooms, I never save anything from chat rooms. That's gone as soon as it's sent, and that doesn't even get saved to hard drive ever.
And do I take it you look through every one of these 26 categories and made, I'm sorry, there are 31 on page 12. You've looked through all of these 31 requests
Yes.
and made searches for everything within them.
Yes.
And they would either be on your computer or in a stack of papers in your basement.
Yeah, either there or on the computer or just non-existent.
How high is that stack of papers in your basement?
Pretty formidable, but
3 feet or 10 feet?
it's more like mailbags filled with information. And it's basically old financial records, things like that. It's all pretty well labeled, so I had no trouble finding. I had no trouble finding old financial records. So
each document there is labeled?
Well, we put them in envelopes. We put them in envelopes and label what they are. So if it's a tax return from this particular year, that's where you find it.
What are the other categories?
Basically, subscriber email, not email, subscriber mail. People who send mail to us wanting to subscribe. We save that. Old bills that we pay, things like that.
What other things are there?
That's about it. It's just there's an awful lot of it that accumulates over the years.
So you say some old emails?
No, not emails. I misspoke. Just mail. Regular paper mail that gets sent to us. Someone writes us and says they want to subscribe. We save that for in case they need to access it in the future.
What is the Electronic Frontier Foundation?
EFF is an organization that basically keeps an eye on the various laws being passed that affect electronic liberty and freedom and that kind of thing. This sparked their interest.
What does electronic freedom mean?
What's my opinion?
When you use it,
basically having the same rights on the net as you have in real life off the net. And also keeping an eye out for privacy invasions by whatever powers it be.
Does it relate to any rights you have with respect to DVDs?
They saw the former question. They saw the lawsuit against us as something that they wanted to challenge.
They saw who's that?
EFF.
I think you said the Electronic Frontier Foundation.
Right.
Supports having the same freedom on the internet one has in real life. Is that correct?
Well, that's my interpretation. I'm not quoting them saying that, but that's...
I just want to make sure I didn't misquote you.
That's what I believe.
Okay, and does that relate to DVDs, I asked you? Can you answer that yes or no and then explain it?
Yes, in this case, because the whole concept of fair use, the whole concept of being able to engage in free speech, it's related to this whole DVD issue.
What speech is being attacked?
Object to the form of the question.
Speech in the form of source code, speech in the form of being able to communicate openly about encryption and to compare techniques of encryption. So that's basically how that relates to speech.
Did you have any communication you received from Roman Kazan or Sean Ramirez?
No, I've never. I mean, I spoke to Roman Kazan in person at the Linux Expo in, I believe it was January, and the other person I've never met.
What are you talking about?
Oh, I hadn't seen him in a while, so we talked about a bunch of things. He's a friend of mine from years ago. And basically, he runs an internet service provider. Basically, he has a lot of customers that use his system. And he was just very worried about having to deal with a lawsuit and having to expose his subscribers to that. And that's eventually why he dropped out of the case.
Now, the stacks of paper in your basement, you said many of them related to financial information?
Attic, yeah.
And the attic, I'm sorry.
Just, tax returns, a lot of stuff that my accountant already has and has better copies of. Receipts, things like that, I like to save things.
Turning to 26. Turning to 26 in that document for page 11. Did you understand that to ask you to produce all your financial records?
Yes, and that has all been produced.
It's all been produced?
Well, it's produced to us.
Right.
I didn't ask you. I'm asking your witness. I didn't ask for your understanding. I'm asking your witness. Not you.
Just
don't answer questions for your witness, Mr. Garbus. Thank you. What's your answer?
They were produced to our attorneys, yes.
Yeah, and where are they now?
I imagine they're still there. They were produced late last week.
You've taken them all out of the stack?
No, actually, I verified that my accountant had better copies of that. I figured those are the ones he wanted.
Your accountant sent them to you, or you got them?
I contacted our accountant, and he FedExed them, I believe, last Thursday. So they should have received it on Friday.
You haven't turned those over, have you, Mr. Moore?
I would have to speak to Mr. Hernstead.
You don't know?
I don't know.
I know at the time they came that my attorneys were in California, so that probably accounts for why it may have taken.
Sorry, I know at the time
my attorneys were in California, so that probably accounts for any delay.
If you turn to page 9 of the document, Ms. Wilson, number 14 at the bottom, did you understand what that called for?
Yes.
And what was your understanding?
Those are log files.
Yes.
Those are files that basically show who hits your website, how often, what pages they look at. I talked to my webmaster about that, and since I believe it was since last summer, we haven't kept log files. I know he found a couple of test log files that he ran, I believe it was sometime this spring, but we had a problem with we had so many hits coming in that it caused problems with our site, because what you do with log files is you go through them all, and you come up with percentages. You say this many people from this kind of a site hit this particular page, and we did this once a week on Sunday nights, and it turned out that what happened on Sunday nights, there was so much activity and these files became so big that our system would crash. And after a while, visitors to our site from years ago remember that we had a counter on the front page that says how many people had gone to the front page. Every time the system crashed, that number would go back down to 1. And it got kind of embarrassing after a while that our large number was always going down to 1. So we just said, enough, it's not worth it, let's just stop, because we have a lot of people visiting the site, that's what's important, and the logs really don't matter that much. And they really don't, because we don't care who's visiting our site, we don't care what they're looking at. Obviously people are visiting the site, that's all that really matters. And plus we just don't have the staff to deal with this. If we were a big company, we had a lot of people, we could give somebody the job of watching over the logs and making sure the machine doesn't crash. But basically we're talking about 2 people running this thing.
Well,
so it wasn't
your webmaster took to test. I couldn't remember the word you used. 2 tests, something or other.
Test log files.
Test log files. Mm-hmm. And where are those?
I believe he submitted those
to
our attorneys. I believe they were submitted late last week, maybe even early this week. I had a little bit of trouble getting a hold of him, but I know he did submit them.
You submitted the originals and not copies?
You can't really do that. It's a file. So he sent a copy of the file to our attorneys. Yeah.
And Mr. Waters, have you turned those over to us yet?
I would have to speak to Mr. Hernstead.
Because if you have, we don't know about it. Oh, by the way, I did want to mention on the record, since we had put so much on the record earlier on the subject, you had several times made an offer to continue the deposition today for the rest of the afternoon while some of us went to court. And I said I thought that I had to be in court. I still think I have to be, but I did say after a bit that we could do that. But you changed your mind, I gather. You don't want to do that.
Well, what I determined was that issues came up this morning that if Mr. Hernstedt did not know about it, he would be at a disadvantage, so I ought to be there. And in exchange for that, I had suggested that we start early tomorrow morning so that if we've lost 2 hours, Mr. Goldstein and I would be prepared to start at 8 o'clock tomorrow morning or 7:30 to make up for the lost hours this afternoon.
And do you remember
you indicated to me you could not do that.
Do you remember that Mr. Hernstedt was here all morning?
Yes, he was here all morning. He left when he had to prepare his argument for court this afternoon.
So what came up this morning that he wouldn't know about?
What came up this morning that he would not know about is the whole question of what documents were produced and what documents were not produced. In other words, your discussion, basically, of this document, Plaintiff's First Request for Production of Documents, which has fundamentally been in Mr. Hernstedt's hand, came up after Mr. Hernstedt left. And you were making all kinds of implications about Mr. Hernstedt did do or didn't do.
Well, I'm very capable of saying precisely. I'm very capable of saying precisely what each of you have done if I knew, and you won't have any questions about that if I actually have evidence that something untoward took place. You'll know that I'm making that claim. You won't have to impute it.
Mr. Gold, this is kid stuff.
Yeah.
It's just posturing.
Right. What option does one have to be?
One always has the option to be above it.
I'm going to ask you, Mr. Gorbis, to specifically represent whether you're going to turn those documents that may not have been turned over to us tomorrow.
I'll take it under advisement.
You won't tell me that you will?
No, of course. I will turn over to you, and I thought I've made it very clear, any document that comes within the ambit of this request. You've asked for documents going back. I'll just go down through it. We will give you absolutely everything.
When?
As soon as we can get it. Now, to the extent that Mr. Hernstedt has it, no. To the extent that Mr. Hernstedt has it, you will get everything by 9 o'clock or 10 o'clock tomorrow before the deposition starts.
Gee, I understand that. Thank you.
To the extent that we leave court early, you can get everything that Mr. Hernstedt has by 6 o'clock.
I understand that also.
This evening.
And thank you.
So that if we get out of court at 5 o'clock, I would hope that Mr. Hernstedt would come back to the office. I do not know whether these documents are date stamped or not. All the documents that the witness is referred to, I presume, arrived while we were in California doing the deposition of Mr. Hoy. I don't know whether they've been date stamped or not, but we'll make every attempt to date stamp them and get them to you as soon as feasibly possible.
So maybe not tomorrow.
Oh, no. The question is whether we get it to you tonight at 6, but certainly by tomorrow morning. To the extent that we have them. Now, my understanding is, I don't know whether we have, given the breadth of your requests, all of the documents you're referring to, but we will give to you everything that we have. Anything that came from Mr. Goldstein to us, we will make sure that you have. Again, my understanding being that in the previous motions, we supplied you with about 200 pages or 300 pages of the exact same material you're seeking, including those documents which Mr. Goldstein referred to in his affidavit, which you have on the table, and also the articles and editorials that were written at 2600.com, some of which you have already used in the cross-examination of Mr. Goldstein. We've also given you, as I understand it, copies of the Hackers Quarterly at some time before today. Okay.
Was that one or two sentences?
I stated it as one sentence without commas or dots.
Thank you, sir. Mr. Goldstein, what hacks, to your knowledge, has 2600 ever reported on?
I'm not sure what you mean by hacks.
You don't know what a hack is?
You define it differently than he, Mr. Gold.
How do you understand a hack?
There's all kinds of definitions. So if you be a little more specific, I can...
I'll try, sir.
Okay.
Has 2600 ever reported on a circumstance where a corporate or personal computer site was gotten into by any individual?
Are we talking about a web page being hacked?
Yes, to begin with.
Yeah, we've reported on web pages being hacked.
Tell me which of those you remember.
Gosh. Well, let's see. There were a lot of Chinese web pages that got hacked. I remember the Department of Justice was hacked a while ago. NASA gets hacked every few months. Basically, quite a few companies that are on the net get hacked. I mean, it's almost a rite of passage. What we do, actually, we haven't done it in a while because we just don't have the staff to keep up with it. Other sites do a better job. But when a site gets hacked, someone notices it, sends us mail, and we capture it. We copy the files and post it in our library.
For what purpose?
To report on it, to show people this security failed. You know, this is what was put up on this site. What the motives are of people who do this is not something we try and pass judgment on. Some people do it as a political statement. Some people do it because they're immature. You know, some people have, you know, nefarious, purposes. It's not our place to say, you know, this is done for this particular reason. We just show, or we did show, what it looks like, and if possible, how it was done, and what it was that failed.
And that's solely for the purpose of letting people know that it happened.
Yeah, it's a news story. I mean, the mainstream media does the same thing, except they generally lack the technical detail, and lots of times they don't provide specifics. And there's a lot of innuendo, a lot of hysteria that goes along with those reports that we try to avoid.
So, when you report on them, do you ever post an executable software utility?
Executable? No, that's not how it works on a web page. It's just a graphical file.
Do you ever post algorithms in connection with those instances? Do you give any technical description of those hacks?
If we receive technical information as to how it's done, yes, we provide that.
Do you make any difference in your own profession between journalism and civil disobedience?
Well, yes, I think there.
What is the difference that you make?
Well, journalism is reporting on something, obviously. Civil disobedience is taking a stand, a nonviolent stand against something that you think is wrong. It's a sad day if journalism and civil disobedience become the same thing, but it has happened in some countries.
Do you remember ever writing in the 2600 publication that mirrors of DeCSS were a demonstration of electronic civil disobedience?
Yes.
And what does that mean?
It basically means that despite the fact that we're being threatened by all kinds of powerful entities, for people, many of whom are very small, poor people, individuals around the world, for them to actually stand up and say this is wrong and stand up against those entities, to me, that's an admirable thing. To me, that's basically putting your beliefs in front of your personal safety, which is what civil disobedience is. It's lying down in front of bulldozers. It's blocking streets and being arrested. This is a case of electronic civil disobedience where people say this is wrong, and I'm going to put my site on the line because I believe it's wrong.
Does civil disobedience involve breaking the law for a cause you consider just?
I'll object to why don't you take the definition? Civil disobedience is a very complex thing.
I don't
witness.
Oh, well,
You have to say that you're limited.
thank you.
Your knowledge is so limited.
Thank you so much, Mr. Gordon. That's very kind.
You also do a distinction between his role as...
You're not testifying, Mr. Gordon. You are not testifying, Mr. Gordon. What about this question bothers you so much?
I have no awareness of what you're talking about. It's embarrassing. I would think you'd be embarrassed. Go ahead, Mr. Goldstein.
I really need to hear the question again.
Does civil disobedience involve breaking the law for a cause you consider just?
Yes, I believe so. That's the definition
You
of civil
understood my
disobedience.
question, didn't you? Is that why you answered it?
I'm not going to take sides here, but...
Thank you, Mr. Goldstein. Has 2600 received any benefit from being a plaintiff in this action?
The defendant.
Defendant. Thank you.
They'd like to be defended.
Well, morally, yes. We've found many people support us, and it's been very heartening to see that. It's also been pretty terrifying and sobering, knowing what we're up against. So I'd say there's a little of good and bad.
What are you up against?
Well, we're up against some pretty powerful entities. I mean, for instance, when we have media people who want to interview us, 9 times out of 10, turns out their parent company is suing us. So it's kind of hard to believe that fair stories will be written in cases like that.
Have any unfair stories been written about you?
Yeah, quite a few.
In what publication?
Publication. I'm thinking specifically of MTV, which is owned by Viacom. Did a really bad piece. That was last year. That was before this all happened. But it's something we're used to. We're used to bad media because they don't understand the issues and because they want the sensationalist headlines of saying, hackers can do anything, and they don't do the research. We have had some very good pieces as well. We've had a good piece in the Village Voice and the New York Times. So it's worth the risk because I think we do get some reporters that understand what's going on.
Do you believe hackers can do everything?
No.
Didn't you say that any protective code would be uncovered, discovered, undone by hackers?
Yeah, hackers can figure things out, but it takes time. It doesn't mean they can do anything. It means that if a particular form of technology, very often written by hackers, can eventually be figured out, undone, defeated.
So the terrifying instances you're talking about are instances where newspapers write some story about you?
No, the terrifying things...
Misstating the witness's testimony.
The terrifying things are facing this kind of a lawsuit. Knowing that everything we've worked for over the past 15 or so years can be unraveled this easily, and that so much time and effort can be spent on this, and that our progress can be slowed down to nothing.
When was the anti-circumvention provision enacted into law, if you know? Was it 15 or 20 years ago?
No.
Well, is it true that you were terrified by the fact that some companies have brought a lawsuit against you alleging that you violated their rights?
It's the might that's focusing on us that's terrifying, not what they say we've done, because obviously we don't believe we've done anything wrong.
What has that might done to you other than file a lawsuit?
It's a psychological thing. It's knowing that that some of the entities are controlled by these 8 companies. And for instance, we had problems with a bank because they had changed their policy towards internet sales, which we've started to get involved in. And the way that they suddenly decided that we were a risk to them made us wonder, were one of these 8 companies behind it? And it was very easy to find links between them and the 8 companies because these 8 companies are linked to everybody. So it's a psychological thing in that every time something bad happens, you wonder, is it because of some of these powerful people? I mean, we all watch the movies. We know what kinds of evil things can go on. So your imagination can run away with you sometimes, but a lot of times it's accurate.
Some of us read newspapers and find out what terrible things have gone on.
that a question, Mr. Gold?
And isn't it a fact that some of us go to movies and find out that hackers have done terrible things if we believe what the movie is portraying?
If you believe what the movies portray about hackers, then there's not much I can say, really.
Who knows the truth about hackers other than you?
Objection is to form direct witness, not notice.
Not to answer or to answer? Okay. I'm sorry, could you repeat the question? I just want to make sure I read it.
Who knows the truth about hackers other than you?
I don't think there is a truth. I think there are elements of truth, and I think, I've got a few of those elements. I think a lot of people in the hacker community have a few of those elements. Unfortunately, I believe a lot of the media doesn't really want to get the true story. They've written the story before they actually interview the people.
Is it true that some people believe that of you?
Oh, I'm sure some people do.
Depends on which side of the matter you want.
It depends what they believe when they read, absolutely.
Paragraph 13 of your May 3rd declaration. Can you mark this as the next exhibit, sir? Yes, we're getting to. Off the record. You two can take a break if you want.
I'm fine.
The time is 2:50 p.m. We're going off the record. Time is 2:52 p.m. We're back on the record.
Is it true, sir, that you stated on the record a short while ago that you believed some bank you were trying to open an account in wouldn't do it, and you believed that was because they were owned by or connected to one of the plaintiffs? Do you remember that comment? I asked you if you wanted to let your witness answer. Did you state it or you didn't state it?
I stated that we had problems with the bank, and we, in our minds, had to wonder if that was caused because of an affiliation. In other words, any bad thing that happens to us, we have to wonder, is there a connection? Because there are definitely connections. A lot of these corporations are linked together, and it's something to definitely be worried about. It's a psychological thing.
And you say that you're serious about this, I gather, that anything bad that happens to you since this suit was started, you believe is the fault of the movie company?
It's not what the witness said.
No, it's.
I mean, you just misstated it. He's been the subject of a press release vilified. He's a liar and a thief. How can that not have a consequence in effect with the bank?
You want to repeat what Mr. Gorba said? That he's told you what to say?
No, it's basically, we investigated and found that there was no truth to that. But what I was trying to convey is that there's a psychological thing that goes on when you have all these powerful enemies, and it wouldn't be untrue to say that you become a little bit paranoid, and you start to worry about things that you wouldn't ordinarily worry about, and that's what I consider to be the scary part of this. And of course, I'm not saying that there aren't real threats out there. I'm sure there are. I'm sure that this has had an effect on the fairness of the media coverage that we get.
Why are you sure of that, sir?
Because that's the nature. If a particular media outlet is owned by a different corporation, of course, on the record they will say that there's no effect, that ownership has no effect. But I think it's been proven time and again that ownership of media outlets does definitely have an effect. For instance, ABC is owned by Disney and has recently been accused of not airing stories that are critical of Disney, even though it was said at the time of Disney's takeover that there'd be no effect on news. When Time Warner purchased CNN, again, it was said that there'd be no effects, and I've heard allegations that there are. It's a common practice when corporations take over other corporations that there is some influence. So when you're dealing with things like the media, which I believe should be independent of all this, it's inevitable. It's rather sad because I think the American people wind up losing.
On that note, Mr. Gould,
don't confuse me. I'm good, but I'm not that good.
We can discuss that at a later time. It's now approaching 2 o'clock. Should we take over?
Sure.
And tomorrow morning at 10?
Okay. Time is 2. You have to send you that point.
Not until I read this over. A lot of it, I think some of it has already been done. I hope it's done. I never will.